The stumps were still bleeding when I pulled into my driveway. 18 trees, gone. 22 years of growth, reduced to 30-centimeter wounds seeping yellow resin into the July dirt. The north fence line, the one that had taken me a full decade to grow into a wall, was nothing but open sky and sawdust still warm under my boots. They did it while I was away. 3 days. They waited until I left. A yellow envelope was stapled to the post. I didn't open it, not yet. I went inside and got my camera. They had no idea what they just started. Drop a comment. Where are you watching from today? The stumps were still bleeding when I finished counting them the second time. 18 Arizona cypress, planted in 2002 when this land was nothing but dry Texas clay and surveyor's stakes, reduced to 30-centimeter wounds seeping yellow resin into the July dirt. Not trimmed, not pruned, taken down to the root collar with a chainsaw, clean and deliberate. The sawdust was still pale gold, not yet oxidized by the heat, which meant the crew had finished sometime in the last 48 hours. I had been at Cedar Pine Lake since Tuesday morning. Someone had known my schedule. I walked the fence line from the eastern corner to the western edge, 41 meters, pressing my boot against each stump to test the moisture of the cut. Still soft, still fragrant. The resin that had bled out overnight had pooled in the bark rings like amber forming in slow motion. At stump number 7, I crouched and looked north across the property line. For the first time in over a decade, I had a clear and unobstructed view of Diane Holst's living room window, and her window had a clear and unobstructed view of Cedar Pine Lake. I stayed crouched for a moment, then I walked back to the fence post. The yellow envelope carried the Cedar View Shores HOA logo on the flap. Inside was a single page signed by Diane Holst, chairperson. It cited Article 7, subsection 4, paragraph B, the Emergency Enforcement Authority provision, and described my cypress trees as an immediate hazard zone under the Summer Fire Prevention Protocol. The letter offered $2,400 as good faith reimbursement. Someone had handwritten in the margin, "Hope this resolves things, Marcus." I folded the letter back into the envelope and put it in my breast pocket. Then I went inside, changed into field boots, and retrieved my DSLR camera from the hallway cabinet. Not my phone, the DSLR, because its raw files embed GPS coordinates and precise timestamps that carry weight in Texas civil proceedings. I loaded a fresh memory card, checked the battery, and walked back out into the heat. 2 hours of methodical work followed. I photographed each stump from 4 cardinal directions, close enough to capture grain pattern and ring count. I documented the sawdust distribution, which revealed the cutting angle and the direction each tree had fallen. Near stump number 12, I found boot prints pressed deep into the damp soil, size 12, chevron tread, the weight signature of a large man. I photographed those too. By the time I finished, the memory card held 214 images, each embedded with a timestamp and a GPS coordinate, accurate to within 3 meters. I sat on my tailgate and drank water while the morning heat settled over the property. My neighbor Carl passed on his quad and raised a hand. I raised mine back. To anyone watching, nothing unusual was happening on the Webb Ranch. That was exactly how I needed it to look. At 11:15, I made the only phone call of that day. Tom Briggs, ISA certified arborist, answered on the second ring. I told him I needed a full damage assessment on 18 mature cypress trees removed without authorization from my private lot, and to bring his full evaluation kit. He arrived at 2:47, 90 minutes before Gary Tilson pulled up in the HOA's white SUV. Gary was sweating through his collar before he reached the fence line. He cited Article 7, subsection 4, paragraph B. He used the phrase community safety 4 times in 3 minutes. He explained that the HOA had acted under emergency authority as a precautionary wildfire measure and that $2,400 was a generous gesture under the circumstances. I let him finish. Then I asked one question. Do you have a fire hazard assessment signed by a licensed engineer documenting these specific trees as an immediate risk? Gary opened his folder, looked at it, and closed it again. He did not have that report. Nobody had ever written it. "Thank you for coming," I said, and walked back toward Tom Briggs. That evening, I opened both versions of the Cedarview Shores HOA bylaws, the 2003 original I had saved at closing, and the 2019 amendment currently posted online. I read Article 7, subsection 4, paragraph B in each. The Emergency Enforcement Authority in the newer version applied to common areas only. My land was a private lot, and it had never been anything else. I had the county survey plat to confirm it. I looked at the ceiling for a moment. Then I opened a new email, attached 214 photographs, both bylaws versions and my survey plat, and hit send. Elaine Cho's office was on the 4th floor of a building in downtown Cedar County that smelled like old carpet and window unit air conditioning. She had a single-frame certificate on the wall, her ISA Arborist Partner certification, a detail I noticed because it meant she understood tree valuation law at a technical level most property attorneys did not. She let me present the situation for 22 minutes without interrupting once. When I finished, she uncapped a pen and asked me one question. "How far back does your photo archive go?" I told her 12 years, at least once per week, stored on an external drive with automatic date stamping. She looked at me for 3 seconds with an expression that was not quite surprise and not quite satisfaction, then said, "Good, here is what we are going to build." The first week was documentation. I pulled every photograph from my archive going back to 2012 and organized them by date into a folder structure Elaine's paralegal could work with. The images showed the cypress trees at every stage of growth: small whips in 2012, shoulder high by 2015, towering and dense by 2022. More importantly, they showed consistent health: no brown patches, no dead limbs, no fire ladder vegetation building up at the base, no evidence whatsoever of the hazard condition that Diane Holst's letter had described. Google Earth historical imagery, which Elaine's office pulled and time-stamped through the Pro Archive tool, corroborated every frame. Tom Briggs delivered his completed report on day 9. 34 pages, spiral-bound, with a blue cover that said, Arboricultural Assessment and Valuation Report, Web Property, Cedar Pine Lake, Texas, across the front. The methodology was the ISA trunk formula method, the recognized industry standard for calculating replacement value of mature ornamental trees. His findings were precise. 18 Arizona cypress, planted in 2002, average trunk diameter of 21 centimeters, average height of 9.5 meters at time of removal, all showing growth rings and tissue density consistent with excellent long-term health. 0 indicators of fire hazard. 0 indicators of disease or structural instability. Total calculated replacement value, $187,400. Replacement timeline to equivalent size, 18 to 22 years minimum. Tom signed and notarized every page. On day 11, Elaine filed a preservation of evidence notice with Cedarview Shores HOA, formally demanding that the organization retain and not destroy all internal emails, board meeting minutes, contractor correspondence, and financial records related to any discussion of my north fence line vegetation dating back 36 months. This was a standard legal instrument, but its effect was immediate and specific. It meant that if the HOA deleted or altered any of those records, they would be committing spoliation of evidence, a separate legal violation that courts treat with significant hostility. The HOA had 10 business days to acknowledge receipt. It was on day 11, in the same conversation where Elaine explained the preservation notice, that she showed me the second thing that would change everything. She had pulled the original 2003 survey plat for my parcel, the meets and bounds legal description filed with Cedar County at the time of purchase. She placed it next to the HOA's own common area map, the one used to define where their bylaws actually applied. The north fence line of my property, the precise line where my cypress trees had stood, sat 11 feet outside the boundary of any HOA common area. It had always been outside that boundary. Every single tree that was removed stood on private land over which the Cedarview Shores HOA held exactly zero enforcement authority under any version of their governing documents. Then she pointed to something else. Under Cedar County Environmental Code, Section 14, subsection 3, any tree with a trunk diameter exceeding 6 inches on private agricultural land was classified as a protected heritage tree. 16 of my 18 stumps measured above that threshold. Removing them without a county permit carried a civil penalty of $10,000 per tree. What Elaine had just described was not a bylaws dispute. It was criminal trespass on private land, destruction of protected natural resources, and a civil liability exposure that no HOA board should ever have allowed itself to walk into. She wrote one word on her notepad and slid it across the desk. Trespass. I looked at it, picked it up, folded it in half, and put it in my shirt pocket next to my pen. I asked her what the next step was. She said, "We wait for them to respond, and while we wait, we finish building the record." I told her that was fine. I had been patient for 12 years. I could manage a few more days. Meanwhile, on the other side of that fence line, Diane Holst hosted a Saturday evening gathering on her back deck. I did not attend, obviously, but one of my neighbors, Carl, 2 lots south, mentioned it to me the following week with the careful, sideways tone of someone who is telling you something they are not sure you want to hear. Diane had looked out at the lake view from her newly unobstructed window and said, loudly enough for several guests to hear, "I finally got that mess taken care of. Should have done it years ago." When someone asked whether I had pushed back, she had smiled and said, "He's been quiet as a mouse. I think he knows when he's on the wrong side of things." Carl looked at me when he told me that part. I thanked him for letting me know. I drove home, opened my laptop, and added his name to the witness list. Let's pause here for a second, because I want you to sit with what just happened. Diane Holst is standing on her back deck, glass in hand, looking at the lake view she wanted, completely convinced she won. She has no idea that 11 feet away, on the other side of that fence line, the most dangerous thing in Cedar County is already being assembled. Not a weapon, a file. Drop a comment right now. Are you the kind of person who would have stayed quiet this long? Because I genuinely want to know. The HOA's formal response arrived on the 14th day, one day before Elaine's deadline. It came on Cedarview Shores letterhead, signed by Diane Holst in blue ink, and it was the single most self-incriminating document I had ever seen produced by a party that presumably had access to legal counsel. I read it twice at my kitchen table before I called Elaine. When she picked up, I simply said, "Their response letter arrived. I'm going to photograph it and send it to you right now. Read it before we talk." She called back 11 minutes later. Her first words were, "Marcus, they just wrote our case for us." The letter opened by reaffirming the HOA's position that Article 7, subsection 4, paragraph B authorized the emergency action. It then stated, in plain language, that the board had voted to proceed with the removal at an internal meeting held on the 8th of July, 6 days before the crew arrived at my property. It named the contractor, Happy Oaks Tree Service. It confirmed that the HOA had executed a signed service agreement with Happy Oaks on behalf of the board. It explained that advance notice to the affected property owner was deemed unnecessary under the emergency provision. And in the third paragraph, with no apparent awareness of what it was admitting, it referred to the location of the work as the vegetation along Mr. Webb's lot line. Not common area, not shared space, but my lot. My private land. The letter then reiterated the offer of $2,400 and requested that I sign an attached acknowledgement form, confirming the matter was resolved. Elaine identified 4 specific phrases that she highlighted in yellow when she printed the letter. First, Board vote on July 8th, which established premeditation, eliminating any good faith emergency defense. Second, service agreement with Happy Oaks Tree Service, which created a clear chain of command and implicated the contractor directly. Third, Mr. Webb's lot line, which demonstrated the HOA's own acknowledgement that they were acting on private property. Fourth, advance notice deemed unnecessary, which confirmed the deliberate decision to exclude me from the process. Together, those four phrases transformed what might have been characterized as a misguided but arguably defensible interpretation of HOA authority into documented intentional trespass with malicious execution. 2 days after the letter arrived, Diane Holst called my personal cell phone directly. She did not go through a lawyer. This was her second significant error of the month. I answered, I listened, and I said almost nothing. She spoke for approximately 6 minutes in a tone that moved between collegial and slightly condescending, explaining that she had taken a difficult but necessary action for the good of the community, that the cypress trees had represented a real and documented fire risk. She did not explain what documentation she was referring to, and that the $2,400 offer was, in her words, frankly more than generous given the regulatory context. Then she asked me if I could just see my way clear to signing the acknowledgement and letting the neighborhood move forward in a spirit of cooperation. I told her I appreciated the call. I asked if she would be willing to summarize her position in an email so that I could review it carefully. She said yes without hesitation. 2 hours later, the email arrived. I forwarded it to Elaine without comment. Her response was 3 words: print and frame. The email confirmed everything this letter had said and added several details Diane had apparently felt comfortable sharing in what she must have imagined was a private channel. She mentioned that the decision to act during my absence had been a scheduling practicality since the crew was available that week. She mentioned that the board had discussed my tree line at 2 previous meetings before July, which pushed the premeditation window back even further than the July 8th vote. And she wrote, in the second to last paragraph, that she hoped I would understand that the HOA existed to serve the collective good of the community, and that sometimes individual preferences had to yield to the needs of the whole. I thought about the view from her back deck. I thought about the word collective. Then I closed the email, opened my contacts, and confirmed Tom Briggs's expert witness availability for the following 3 months. That same week, Elaine sent a formal preservation notice to Happy Oaks Tree Service as well. Their attorney responded within 48 hours, which told us everything we needed to know about how exposed they understood themselves to be. The contractor was not interested in absorbing liability for a client who had apparently not disclosed that the removal site was private land outside HOA jurisdiction. Within 10 days, Happy Oaks had quietly retained separate legal counsel and begun the process of providing full documentation of their engagement with Cedarview Shores. The original inquiry email, the signed service contract, the work order, and the payment confirmation from the HOA's operating account. They also provided something we had not specifically requested, a cue sheet from the job foreman, handwritten, noting the crew arrival time, site conditions, and a brief note that read, "Client rep on site, confirmed go ahead." The client rep was Gary Tilson. The date was July 14th. The time was 6:22 in the morning. I had left for the lake at 5:45. Gary Tilson had stood on my property at 6:22 in the morning and given the signal to begin cutting my trees. That note, written in a foreman's handwriting on a contractor's job sheet, was now in Elaine's file. Nothing about this case would ever feel urgent or rushed, but sitting in Elaine's office that afternoon, watching her slide the job sheet into a labeled tab in the evidence binder, I felt the particular quiet satisfaction of a man who has laid every stone in a wall and knows it will hold. The demand letter that Elaine sent on a Tuesday morning was 11 pages long, single-spaced, and addressed simultaneously to 4 parties: Cedarview Shores HOA as an organization, Diane Holst in her personal capacity, Gary Tilson in his personal capacity, and Happy Oaks Tree Service. I had read a draft the previous Friday and suggested 2 clarifications in the technical sections. Elaine had incorporated both without comment. The final version went out by certified mail and electronic delivery at 9:14 in the morning. By 9:45, I was back at my property doing routine maintenance work on the south fence. I did not wait by the phone. There was nothing to wait for yet. The letter had a 21-day response window and a set of demands that no rational party was going to answer with a casual yes. The claims were organized in 4 sections. The first addressed trespass to land, intentional entry onto private property without authorization, without a court order, and without a statutory basis, resulting in permanent destruction of fixtures attached to the land. The second addressed conversion of personal property. The cypress trees, as established by Texas Property Code, constituted personal property of the landowner, and their removal without consent constituted conversion, a civil wrong distinct from and in addition to the trespass claim. The third section cited the Cedar County Heritage Tree Ordinance directly. 16 of the 18 removed trees qualified as protected heritage trees under Section 14. Subsection 3 of the County Environmental Code, with a civil penalty schedule of $10,000 per tree, a figure that belonged to the county's enforcement track, running parallel to and independent of the civil suit. The fourth section was the one I had spent the most time reviewing. It cited Texas Civil Practice and Remedies Code, and it invoked the treble damages provision applicable to intentional destruction of property with demonstrated malicious intent. The base figure, Tom Briggs's certified valuation of $187,400, multiplied by 3, produced a civil damages demand of $500 to $62,200. Elaine filed the county complaint simultaneously. The heritage tree violation notice went to the Cedar County Environmental Code Enforcement Office with a complete copy of Tom's report and my photographic record. The county had its own timeline and its own enforcement mechanism, entirely separate from the civil proceedings. Within 5 days, code enforcement had issued a notice of violation to both Cedarview Shores HOA and Happy Oaks Tree Service. 16 counts, $10,000 each, $160,000 in administrative penalties, independent of anything a civil court might later award. Happy Oaks, already in communication with their own counsel, immediately began formal cooperation with the county investigation and submitted a written statement identifying the HOA as the directing party who had represented to them that all necessary permits and authorizations were in place. That representation had been false. The contractor had relied on it in good faith. The HOA now held full exposure on the county side as well. The Cedarview Shores Board held an emergency session 4 days after the demand letter arrived. I was not invited. I did not expect to be. But 2 board members, people who had served alongside Diane for years and who were now staring at a document that named the organization in $562,000 of civil liability, reached out to mutual acquaintances to ask, with studied casualness, whether I was actually serious about going to court. The answer they received, relayed back to me through the same informal channel, was apparently enough to produce the kind of silence that follows a very bad board meeting. Elaine's office received a call from Robert Finch, the attorney the HOA had retained on an emergency basis, 4 days before the response deadline. Finch was professional and efficient. He acknowledged receipt of the demand letter, confirmed his representation of Cedarview Shores HOA, requested a 2-week extension to respond, and, almost as an aside at the end of the call, mentioned that his client was open to exploring a resolution that served everyone's interests. Elaine granted the extension without negotiation. She told me later that granting it was the right move. It signaled confidence, and confidence in a civil matter is itself a form of evidence that the other side reads carefully. A party that needs more time is a party whose position has not held up under internal review. We gave them the time. We used it to add Gary Tilson's deposition to our discovery request list. I found out about the HOA's internal messaging records on a Wednesday afternoon, when Elaine called me from her car. Her paralegal had completed the initial review of the documents the HOA had been compelled to produce under the preservation notice. Buried in a thread from late March, 3 months and 28 days before the morning Gary Tilson stood on my property at 622, was an exchange between Diane Holst and Gary. In it, Diane had written, "I need to find a way to get those trees gone. I can't see the lake from my own house because of them." Gary had replied, "But that's Webb's land. We don't have authority over..." And Diane had cut him off with, "Find some provision. Use the fire season. Use anything. Just find it." I sat in my truck in the parking lot of the hardware store where I had just bought fence staples and looked at that transcript on my phone screen for a long time. Not because it surprised me, because it was exactly what I had suspected from the moment I saw that freshly cut sawdust on my July morning. And now it was in writing, time-stamped and sitting in our evidence file, every claim of emergency, every invocation of community safety, every phrase in that yellow envelope letter, all of it traced back to one woman looking at a view she wanted and deciding the law was an obstacle, not a boundary. I need you to understand what that March message actually means. Diane didn't react to a fire hazard, she manufactured one. She looked at a lake she couldn't see and decided to create a legal fiction to take what wasn't hers, and then she typed it out in a text message and hit send. That is not a mistake. That is a paper trail. And Marcus Webb had just found the thread that unravels everything. Tell me, are you starting to see how this ends? Because we are just getting to the good part. The counterattack came in 3 waves, and it arrived faster than I expected. Within 10 days of receiving the demand letter, Cedarview Shores HOA filed 3 separate violation notices against my property. The first alleged that my east fence exceeded the maximum permitted height by 6 inches. The second claimed a vehicle had been parked on my grass lawn on a specific Tuesday afternoon. The third stated that my garden lighting was illuminating neighboring properties past 10 o'clock in the evening. I read all 3 notices at my kitchen table on a Thursday morning, finished my coffee, and then opened my external hard drive. I was not angry. I was, if anything, mildly interested in how thin the material was. The fence violation took 4 minutes to disprove. I pulled photographs from 3 weeks prior showing the fence at its current height, cross-referenced against the survey plat measurements Elaine already had on file. I had built that fence in 2014 to the exact specification in the HOA bylaws, and I had photographed it when it was finished because that is what I do with every permanent structure on this property. I forwarded the images to Elaine with a 1-line note. East fence, confirmed compliant, see attached. The vehicle on the grass claim dissolved when I pointed out that my property had a covered carport, built in 2009, visible in every aerial photograph of my lot going back 15 years, and that I had not owned a vehicle small enough to require overflow lawn parking since 2016. The lighting complaint required slightly more effort. I pulled the smart home system log, which recorded every on and off cycle for every exterior fixture on the property, and confirmed that my garden lights operated on an automatic timer that cut power at 9:45 each evening. I also attached the corresponding electricity billing data, which showed usage patterns entirely consistent with the timer record. Elaine sent a single consolidated response to all 3 notices within 48 hours, attaching the relevant documentation for each. She included a cover paragraph noting, with careful precision, that the filing of demonstrably unsupported violation claims against a party who had issued a formal demand letter could be characterized as retaliatory conduct, a characterization that courts in Texas had not historically viewed with generosity toward the retaliating party. The HOA did not respond to her letter. The 3 violation notices were quietly withdrawn from the record within a week. The second front opened online. A post appeared on the Cedarview Shores Community Board, a neighborhood discussion platform accessible to all HOA members. Written under Diane's account, it did not name me. It described, in carefully vague language, a situation in which the HOA had been forced to take protective action against a fire safety threat, and was now facing an aggressive legal response from a property owner who had chosen conflict over community. The post expressed Diane's hope that neighbors would stand together in support of the board's efforts to keep our community safe. Within 24 hours, the post had accumulated dozens of supportive comments. Several named me indirectly. One called me litigious. Another suggested I had something to hide. I did not post a single word in response. I took a full screenshot of the post and every comment, logged the timestamps, and forwarded the file to Elaine with the subject line, "Potential defamation record for archive." She confirmed receipt and added it to the discovery folder labeled HOA Communications, Public Statements. The third front was the one that had actual structural weight, and it collapsed the fastest. Robert Finch filed a motion arguing that the demand letter overstated damages by applying treble multipliers to a valuation methodology that, in his view, exceeded reasonable replacement cost. It was a legitimate legal argument, the kind that gets made in property disputes routinely, and it deserved a legitimate legal response. Elaine filed a counterbrief the following week, attaching Tom Briggs's full 34-page report, his ISA certification credentials, a published ISA methodology guide confirming the trunk formula method as the accepted standard for mature ornamental tree valuation in Texas civil proceedings, and 3 prior Texas District Court cases in which comparable valuations had been upheld. Finch did not file a reply brief. 2 days later, his office called Elaine's office and asked about scheduling a mediation session. Elaine told me that afternoon. "They just told us," she said, "that they don't believe their own defense." Happy Oaks Tree Service completed their cooperation agreement with county code enforcement the same week. They submitted the full contract documentation, the payment records, and a sworn statement from the company owner, confirming that Diane Holst, acting as HOA chairperson, had represented to them in writing that all necessary permits and landowner notifications had been completed prior to the work order. That statement was now a sworn affidavit in 2 separate proceedings. The contractor had handed us the final link in the chain of command, signed and notarized, and walked away from the table with a reduced county penalty in exchange for their cooperation. I did not blame them. They had been lied to. We were not interested in Happy Oaks. We were interested in who had done the lying. The mediation room at the Cedar County Courthouse Annex was designed to feel neutral, and it mostly succeeded. Oval table, cream walls, a window that looked out onto a parking structure. I arrived 8 minutes early, poured water from the pitcher on the side table, and sat with my hands flat on the surface in front of me. Elaine sat to my left, her evidence binder closed, her pen uncapped. We did not review notes. We did not rehearse. There was nothing left to rehearse. Diane arrived with Robert Finch and Gary Tilson. She wore a blazer I had not seen before and carried a leather portfolio that looked new. Gary sat down without making eye contact with anyone and kept his gaze at a fixed point somewhere between the table surface and the window. Diane looked at me when she entered. I looked at my water glass. The mediator, a retired county judge named Harold Voss, called the session to order at 9 o'clock exactly and explained the ground rules with the unhurried efficiency of a man who had done this several hundred times and found the process neither interesting nor tedious, simply necessary. Robert Finch opened. He acknowledged, with the particular phrasing attorneys use when they want to concede without conceding, that there had been procedural irregularities in the HOA's enforcement action, and that his client recognized the need to make Mr. Webb whole in a meaningful way. He slid a document across the table. The offer was $45,000, with a mutual non-disclosure agreement as a condition of settlement. Elaine picked up the document, read it in approximately 90 seconds, set it face down on the table, and said, "My client does not sign NDAs." Finch nodded as though he had expected that, and asked what a productive conversation might look like. Elaine opened her binder and placed the March message transcript in the center of the table. She did not explain it. She let Finch read it. He read it twice. Then he asked for a 10-minute recess. He came back with $120,000. The NDA remained. Elaine's answer did not change. My client's position on the non-disclosure condition is not a negotiating point, Mr. Finch. It is a boundary. Finch looked at Diane, who looked at me. It was the second time she had looked directly at me since entering the room. Her expression was not what I expected. There was no defiance left in it. What I saw was the particular blankness of someone who has only just understood the actual dimensions of the situation they are in, and does not yet know what to do with that understanding. Elaine then placed our terms on the table. Full damages at the treble multiplier, $562,200. Public acknowledgement of the violation at the HOA's next annual meeting. Voluntary resignation of Diane Holst and Gary Tilson from all HOA board positions. No non-disclosure agreement. All proceedings to remain on the public record. Finch read the terms carefully. He asked 3 clarifying questions about the resignation provision. Elaine answered each one without elaboration. Then Finch turned to Diane and said something too quietly for me to hear. Diane set her leather portfolio on the table, pressed her palms flat against the surface, a gesture that was almost a mirror of my own posture when I had arrived, and said, "We'll see you in court." I picked up my water glass and finished the last of it. Elaine clicked her pen closed. Harold Voss noted the impasse for the record and adjourned the session at 10:53 in the morning. Walking to the parking lot, Elaine said, "That's the answer I wanted from them." I asked her why. She said, "Because a settlement with an NDA protects them. A public judgment protects everyone." I thought about that for the rest of the drive home. I thought about every other property owner in Cedarview Shores who had received a violation notice from Diane Holst in the last 9 years and had simply paid the fine, fixed the fence, moved the car, and gone back inside. I thought about what it costs a community when the person holding the gavel believes the gavel is unlimited. Then I thought about the courtroom, and I felt something that was not quite satisfaction and not quite anticipation, but lived in the same neighborhood as both. $120,000 sitting on that table. And Marcus Webb pushed it back. Not because he couldn't use the money, because taking it quietly meant Diane Holst would keep her seat, keep her gavel, and find someone else's trees to cut down next season. That decision, right there, is what separates revenge from justice. Revenge takes the money and goes home. Justice makes sure the next person doesn't need to fight the same battle. I want to know, would you have taken the offer? Be honest. Cedar County District Court, Courtroom 4. Judge Patricia Morse presided from an elevated bench that made the room feel smaller than it was. The gallery held perhaps 30 people, a number of Cedarview Shores residents I recognized, 2 reporters from the Cedar County Gazette, and Carl from 2 lots south, who had taken a personal day to be present, and who nodded at me once when I entered. I sat at the plaintiff's table with Elaine, our evidence binder open to the first tab. Survey plat, county certified, dated 2003. Across the aisle, Robert Finch arranged his documents with the focused calm of a man who had reviewed them enough times to know exactly where his weaknesses were. Judge Morse called the proceeding to order at 8:55 and established the ground rules with 2 sentences. She ran an efficient courtroom. This became apparent within the first 20 minutes. Elaine's presentation moved through the evidence in deliberate layers. She began with the survey plat, the foundational document, the one that established every other argument. She walked the court through the metes and bounds legal description, the GPS coordinates of the north fence line, and the HOA's own common area map, placing them side by side on the projection screen. The gap between the HOA's claimed enforcement zone and my actual fence line was visible to anyone in the room who could read a map. 11 feet of Texas private land that the HOA had never had any authority over, under any version of their governing documents, on any day in the history of Cedarview Shores. Judge Morse asked Finch whether he disputed the survey plat. He said he did not dispute it. She made a note. Tom Briggs testified for 40 minutes as an expert witness. He explained the ISA trunk formula method, walked through his calculations for each of the 18 trees, confirmed his 0 fire hazard rating for every specimen, and stated under oath that in his professional opinion, the removed trees showed no indicators of disease, structural failure, or elevated combustion risk. Finch cross-examined him on the valuation methodology. Tom answered each question with the patient precision of someone who had written 34 pages on the subject and was not going to be moved by a lawyer asking him to summarize it differently. The cross-examination lasted 11 minutes. It changed nothing. Then Elaine introduced the March messages. She read them into the record without commentary, in the flat, even tone of someone reading a bus schedule. I need to find a way to get those trees gone. I can't see the lake from my own house because of them. And then, find some provision, use the fire season, use anything, just find it. The room was very quiet after she finished reading. Judge Morse looked at Diane Holst for a moment, then looked back at her notes. Finch argued Article 7, subsection 4, paragraph B. He had no other argument left. He presented it methodically, citing the 2019 amendment language and the emergency enforcement clause. Elaine's rebuttal was 45 seconds long. She cited the survey plat, already in evidence, already undisputed, and pointed out that the emergency clause, by its own explicit language, applied to common areas only. My land was not a common area. The survey plat confirmed it. The HOA's own maps confirmed it. Finch's own prior acknowledgement in this same proceeding confirmed it. Judge Morse asked Finch to explain the legal basis for applying a common area provision to a private lot. He said his client had operated on a good faith interpretation of the bylaws. Judge Morse said, "An interpretation contradicted by the plain language of the survey, plat your client commissioned in 2003, is not a good faith interpretation. It is an error, at minimum, and the messaging record suggests it may be considerably more than that." She made another note. Diane stared at the table. The judgment came 8 days later in a written ruling. Intentional trespass to land, established. Conversion of personal property, established. Malicious destruction under Texas statute, supported by demonstrated premeditation in the March communications, established. Treble damages applied pursuant to Texas Civil Practice and Remedies Code, $562,200, allocated proportionally across Cedarview Shores, HOA, Diane Holst personally, and Happy Oaks Tree Service per their respective degrees of liability. County Heritage Tree penalties, $160,000, administered separately through code enforcement. Court injunction. Diane Holst prohibited from holding any HOA board position for a period of 5 years. Gary Tilson, formally censured and removed from the board, pending HOA membership vote. The ruling was entered into the public record the same afternoon. The Cedar County Gazette ran it the following morning. The community board post Diane had written, the one about standing together in support of the board's safety efforts, was deleted sometime that evening. Nobody archived the deletion. I had archived the original 3 months earlier. The check arrived by certified mail on a Wednesday, 9 weeks after the judgment. I signed the receipt, took the envelope inside, set it on the kitchen table, and made coffee before I opened it. The total, after proportional allocation and legal fees, was substantial enough to matter and modest enough that I did not feel compelled to do anything dramatic with it. I sat at the table for a while with the check in front of me and the coffee getting warm in my hands, and I thought about the 2002 growing season. The year I had pushed 18 cypress saplings into the dry North Texas clay, staked each one, soaked the root zone every morning for 6 weeks until the roots found the water table on their own. 22 years. That was what had been taken on a July morning while I was catching fish I would have thrown back anyway. Then I called Tom Briggs. We spent an afternoon at the property 2 weeks later, Tom and a landscape architect named Diana, not a name I had any particular reaction to, it was just her name, walking the north fence line and discussing what I wanted to put there. I had a number, I had a legal framework, and I had a county heritage tree registration process that Elaine had walked me through in detail. Any tree planted on private agricultural land and formally registered with the county on the day of planting received protected status from that date forward. Removing such a tree would require a permit application, an independent arborist review, and the landowner's written consent. The process that Diane Holst had bypassed entirely in July would become, for every tree I planted on this fence line, a legally mandatory multi-step process that no HOA board, current or future, could shortcut. I was not building a fence. I was building a permanent legal structure that happened to be made of wood and chlorophyll. The planting plan Tom and Diana developed specified 5 categories of trees and shrubs, selected for a combination of growth rate, mature height, canopy density, and native status under Texas Environmental Code. 18 Leyland cypress from a certified nursery, 5 years old, already 3 meters tall, chosen because they grow 1 to 1.5 meters per year under adequate water. 12 Eastern red cedar, native species, which under county ordinance received the highest tier of heritage tree protection available, meaning that their removal would trigger a full environmental review regardless of who requested it. 8 Italian cypress, narrow columned and vertical, specifically effective at blocking elevated sightlines. The kind of sightline one might have, for example, from a second-floor living room window looking south toward a lake. 3 staggered rows of viburnum hedge running the full 41 meters of the fence line, evergreen, dense at maturity to 4 meters, filling the lower gaps that taller trees leave. 38 plants in total, each one registered with Cedar County Environmental Code Enforcement on the day it went into the ground. Each one photographed at planting with GPS coordinates, the registration number, and my signature on the intake form. The crew planted on a cool October morning. I was present for all of it. I photographed each tree as it was placed, just as I had photographed the stumps 3 months earlier. 4 angles, close focus on the root ball, wide shot showing position relative to the fence line. By 2 in the afternoon, the north fence line of my property held 38 young trees and shrubs standing in 3 staggered rows, and every single one of them was a registered protected heritage tree under Cedar County law. I walked the line after the crew left and looked north through the young canopy. The Leyland cypress were already blocking the lower portion of the view toward my neighbor's property. In 18 months, they would block the middle. In 3 to 4 years, the canopy would close completely. I learned later, through Carl, again, who seemed to have developed an anthropological interest in my fence line situation, that Diane Holst had called a Cedar County land use attorney approximately 6 weeks after the trees went in, looking for a mechanism to challenge the planting. The attorney had reviewed the heritage tree registration documentation and told her there was no basis for a challenge. The trees were legal, properly registered, and planted entirely within my private lot, which I had the right to vegetate at my own discretion. She had then apparently asked whether the HOA could cite me for obstruction of community sightlines. The attorney had told her that Texas did not recognize a legal right to a view across a neighbor's private property, and that no HOA provision could create such a right where state law declined to provide one. I was told she did not say anything in response to that. She just ended the call. I started a new field notebook for the north fence line that October. First entry, planting date, species, registration numbers, initial measurements. I wrote the entry in the same handwriting I had used in the previous 12 years of notebooks, sitting at the same kitchen table, in the same house, on the same 4 acres of private land that had always been, and would remain, entirely mine. Most people, when they talk about HOA disputes, talk about frustration, Petty rules, power-hungry board members, the helpless feeling of answering to an organization that answers to nobody. Marcus Webb's case is worth studying not because he won, but because of the specific way he won, and what that reveals about property rights when you understand them precisely. The first lesson is documentation as infrastructure. Marcus had 12 years of weekly photographs with automatic timestamps and GPS metadata, not because he anticipated a dispute, but because he was methodical. That archive became the backbone of a $562,000 judgment. A smartphone, a consistent habit, and an external hard drive are all it takes. Most people have the first two and never use them this way. The second lesson is about HOA authority and its real limits. Bylaws apply to zones defined by your survey plat and original covenants, not by whatever the board decides to interpret. The difference between a common area and a private lot carries significant legal consequences. Before signing anything with an HOA, have a property attorney read the bylaws against your survey plat. That review costs a few $100s. The fight you were unprepared for costs considerably more. The third lesson concerns non-disclosure agreements. When someone who wronged you offers money for your silence, the silence is the product they are buying. It protects their reputation and their ability to do the same thing to the next person. Understand what you are selling before you sign. The fourth lesson is patient premeditation. Marcus did not act faster than his adversary. He acted more carefully. Every step, the photographs, the arborist report, the preservation notice, the refusal to settle quietly, was a deliberate choice made with the final outcome already in mind. The legal system rewards documentation and process over emotion every single time. Diane Holst wanted a lake view. It cost her $562,000, her board seat, and 38 trees she will never legally touch. They will outlive this dispute by decades. So will the public record of why they were planted.